somewhere between a wedding and a grave, something went quietly, invisibly wrong, and for weeks, no one could prove what. One test, one exhumation, one verdict would finally decide whether it was murder or misfortune. The case of Marie Lafarge begins in Le Glandier, in the Corrèze region of south-central France, in the winter of 1839 and 1840. Corrèze, in this period, was not Paris. It was not even provincial in the genteel sense that word usually carries. It was a department of granite hills, chestnut forests, and small iron forges that had operated, in some form, since before the Revolution, enterprises that depended on charcoal, water power, and a steady supply of ore, and that rose or fell with the price of metal and the competence of the men who ran them. The rural gentry of the region were not the landed aristocracy of the Loire chateau. They were a mixed class of minor nobility, industrialists, and professional men, many of them recently enriched or recently ruined, holding on to status through marriage alliances and inherited land rather than liquid wealth. Fortunes here were fragile, and reputations were currency. A family's standing could rest on a single good marriage, a single functioning ironworks, a single unblemished name, and any one of the three could collapse the others. If this case stayed with you, there are more like it waiting. Subscribe, because some stories deserve to be told properly, not just once, but every time." End quote. The economy of the district ran, in large part, on credit that nobody discussed openly. Ironmasters borrowed against future output. Brides brought dowries that existed more often on paper, in the promise of inheritance, than in coin already banked. Matchmaking agencies, a relatively new and somewhat disreputable institution, treated with a mixture of necessity and social embarrassment, had begun operating out of Paris and provincial towns alike, matching families with capital problems to families with capital, or the appearance of it. It was an economy of appearances stretched over a foundation that in more than one household did not exist. But even that shaky economy needed one thing to survive: distance. And Corrèze, as it turned out, had almost none to offer. The physical geography of Corrèze reinforced this precariousness, rather than softening it. The department sits on the western edge of the Massif Central, a country of steep wooded valleys, thin agricultural soil, and a climate that made large-scale grain farming unreliable. Where the flatter river valleys of northern France could support diversified estates and a cushion of agricultural income, Corrèze's landowners depended disproportionately on a narrow set of enterprises: timber, chestnut cultivation, small-scale metalworking, each vulnerable to a single bad season or a single failed contract. Roads into the region were poor, even by provincial French standards of the 1830s, meaning that news, credit, and reputation traveled slowly outward, but, once a scandal did break, traveled with unusual speed through the tightly interconnected local gentry, who all sat, in effect, on each other's boards, in each other's parlors, and at each other's dinner tables. A rumor at Le Glandier could reach Toul, the departmental capital, within days, and from Toul it had only to reach a single traveling correspondent before it reached Paris. Nothing here stayed private for long. That would matter more than anyone at Le Glandier yet knew. This was also, crucially, a world with sharply limited options for unmarried women of reduced means. A woman born into minor nobility, but without independent capital, had, in practice, three paths: a favorable marriage, dependence on the charity of relatives, or a decline into the kind of genteel poverty that stripped a family name of whatever social value it still carried. There was no fourth option that preserved both economic security and social standing. This structural narrowness is not incidental to the case that follows. It shaped, directly, the decisions available to the young woman at its center long before she ever set foot at Le Glandier. Daily life at Le Glandier moved to the rhythm of the forge, the furnace fires, the delivery of ore, the household servants who came from the nearby villages and who saw, in the ordinary course of their work, far more of a family's private difficulties than any visitor ever would. Servants in this world were not merely staff. They were, whether the families liked it or not, witnesses to arguments, to correspondence left unguarded, to what was eaten and by whom, to who came and went from a sick room. Their testimony would matter more than anyone at Le Glandier could have anticipated in the winter of 1839. What is not established in the sources recovered from this period is any clear account of the victim's inner life before his marriage, his private hopes for the ironworks, his own sense of the debts he carried, the degree to which he understood the financial position he was in. Contemporary records describe Charles Pouch Lafarge chiefly through the lens of business correspondence, legal documents, and the recollections of others. His own voice survives only in fragments. What is not documented is any first-person account, in his own hand, of his state of mind in the months before his death. The record that exists is a record of transactions, debts, and other people's observations, not of the man himself. The domestic arrangement at the center of this case had been formed only months earlier, and it had been formed, by the standards of the district, unusually fast. Charles Pouch Lafarge, master of the ironworks at Le Glandier, was in his early 30s, unmarried, and, this detail would prove consequential in the weeks that followed, in serious financial difficulty. The forge was heavily mortgaged. Contracts had gone wrong. He needed capital, and he needed it quickly, and in the closed social world of provincial courets, the fastest route to capital was still a marriage with a dowry attached. He found his bride through a Paris matrimonial agency, Marie Capel, 23 years old, an orphaned young woman of thin nobility and thinner means, whose late mother had been connected, at some genealogical distance that the family made much of, to the aristocratic Genlis Collard lineage. The connection was real but attenuated, more useful as a claim to respectability than as an actual source of wealth. Marie herself had grown up largely in the households of relatives, educated, cultured, accustomed to genteel society, and increasingly aware, as she reached her 20s without a settled position, that her prospects depended entirely on securing a marriage that her background alone could not guarantee. The two met, by arrangement, in the summer of 1839. They were married within weeks. It was, by any account, a transaction dressed as a courtship. He needed her dowry. She needed his name and his household. What is not documented is any private correspondence establishing genuine affection between them prior to the wedding. What the surviving letters and depositions do establish is that each party arrived at Le Glandier having been led, by intermediaries or by their own hopes, to expect something the other could not fully deliver. He had expected a substantial dowry that proved smaller and more encumbered than promised. She had expected, by her own later account, a country estate considerably grander than the working ironworks she found on arrival, a house she is recorded as describing with open disappointment in letters written within days of her arrival. The property itself, when she first saw it, appears to have compounded rather than eased the mismatch of expectations. Le Glandier had once been a monastic foundation, later repurposed as an industrial estate, and the surviving descriptions depict a dark, damp, functional compound organized around the demands of the forge rather than the comforts of a household, smoke from the furnaces reaching the windows of the family's living quarters, the noise of hammers and bellows a near constant presence, and none of the ornamental gardens or refurbished interiors that a bride raised on stories of aristocratic connection might reasonably have anticipated. Whether this disappointment alone soured the marriage, or merely gave later prosecutors a convenient narrative of resentment to draw upon, is not something the surviving record settles definitively. What is documented is that Marie wrote home, within days of arriving, in terms that made her unhappiness with the match plain to her relatives. Letters that would later be read into the court record as evidence of a wife already estranged from her husband before any question of poison had arisen. Charles Pouch Lafarge himself is described in the surviving depositions and press accounts of the period as a solidly built man of medium height, dark-haired, with the weathered look of someone who spent time on the forge floor rather than solely at a desk. He had inherited the ironworks from his father and had run it, by most accounts, competently, but without the capital reserves to weather a downturn. He was not, in the record, a cruel or dissolute man. He was, more simply, a man under financial pressure who believed a marriage could solve a problem that a marriage alone could not solve. His business history, as reconstructed from surviving ledgers and creditor correspondence introduced at trial, shows a pattern common to many small provincial industrial concerns of the period. A viable operation, undermined by a small number of poor decisions, compounded over several years. An expansion of the forge's capacity, financed by short-term loans. A contract with a metal buyer that fell through after materials had already been purchased, and a slow accumulation of interest payments that consumed a growing share of the work's revenue. By the time he traveled to the matrimonial agency in Paris, colleagues and creditors alike understood, in broad terms, that the ironworks required an infusion of capital within a matter of months, or it would face closure. This is the specific pressure that is documented as motivating his pursuit of a bride with a stated dowry. What is not documented, and what the trial itself could never fully resolve, is the precise moment at which his financial desperation shaded into the decisions, the insurance policy chief among them, that would later be read by prosecutors as evidence of a household already organized, on some level, around his own death. If you find value in stories preserved this way, consider liking the video and subscribing to the channel, and let me know in the comments where you're listening from. Now, back to the record. The marriage did not settle the ironworks debts, and within weeks, the household at Le Glandier was operating under a strain that had less to do with affection than with arithmetic. Charles needed money urgently. Creditors were pressing, and the works could not continue operating without an infusion of capital that the marriage had not in fact produced. He traveled to Paris that autumn to attempt to raise funds through connections and, separately, through an insurance arrangement, a policy taken out on his life, naming Marie as beneficiary, that would later become one of the most scrutinized documents in the entire case. Whether the policy was Charles's idea, Marie's, or a joint decision made under financial desperation is not established with certainty in the sources. What is documented is that it existed, that it was recently signed, and that its timing, mere weeks before Charles fell ill, would be treated by prosecutors as more than coincidence. A third element entered the household's tensions that same autumn: renewed contact, through correspondence and a brief visit, between Marie and a family friend named Charles de Léotot, whose wife would later accuse Marie of stealing a set of diamonds during a visit. An accusation that, though legally separate from the poisoning case, would surface repeatedly during the murder investigation and would be used by the prosecution to suggest a broader pattern of deception. Financial strain in the Lafarge household, then, was compounded by a second, parallel scandal brewing at a distance, one that had nothing directly to do with Charles's health, but that would shape how jurors, and the public, came to see the accused. None of this happened in a vacuum either. A household under this kind of pressure was, in 1839, a household living inside a much larger national mood, one worth understanding before the story turns to what happened inside it. It is worth placing this domestic drama against the broader currents of France in 1839 and 1840. This was the July Monarchy, the reign of Louis Philippe, a period defined by an anxious, commercially minded bourgeoisie eager to distinguish itself from both the old aristocracy and the revolutionary excesses of the previous half-century. The regime's legitimacy rested heavily on an image of orderly, bourgeois domestic virtue, the stable household as a kind of miniature analogue for the stable state, which meant that a case appearing to show a marriage weaponized for financial gain touched a cultural nerve well beyond Corrèze. It was also a period of rapid growth in popular print journalism. Cheap newspapers with wide circulation had multiplied through the 1830s, aided by improvements in printing technology and postal distribution, and criminal trials, particularly those involving women, class anxiety, and domestic betrayal, had become a reliable source of mass readership, sold in serialized daily installments that kept readers returning across the length of a trial. France's forensic and medical institutions were, at the same time, undergoing their own transformation. The discipline of legal medicine, and specifically toxicology, was only then acquiring the analytical tools, most notably an English chemical test for detecting arsenic, refined and adapted by French chemists, that would allow courts to move from circumstantial suspicion to something resembling physical proof. Arsenic itself occupied a peculiar cultural position in this period. It was cheap, widely available as a rodent poison, and in certain cosmetic and medicinal preparations, tasteless in small doses, and, prior to the development of reliable chemical tests, essentially undetectable after the fact. A combination of properties that had made it, for decades, the preferred instrument of domestic poisonings across Europe, precisely because it left no clinical fingerprint a physician of the previous generation could reliably read. The Lafarge case would arrive at the precise intersection of these two developments, a sensational domestic story and a still new science eager to demonstrate, under public and adversarial scrutiny, exactly what it could now prove. Charles Pooch Lafarge fell seriously ill in December of 1839, not long after returning from his trip to Paris. The onset is described in surviving depositions as sudden and severe. Violent vomiting, abdominal pain, a burning sensation reported by the patient himself. He recovered somewhat, then relapsed, in a pattern that several of the household staff would later describe as unusual. Improvement followed by relapse, repeatedly, over a period of weeks, rather than a single continuous decline. According to testimony given after his death, food and drink prepared for him during this period, including a cake sent to him in Paris, and later, eggnog and sweetened water administered during his convalescence at Le Glandier, were prepared or handled by Marie personally, at times when servants recalled being asked to leave the room. The narrative here must be treated carefully, because much of what followed rests on circumstantial testimony rather than direct observation. No witness described seeing arsenic placed in food. What is documented is a pattern, the timing of Charles's relapses correlating, according to servant testimony gathered after the fact, with meals and drinks prepared by his wife, a chemist consulted locally who detected what he believed to be arsenic in a sample of the sickroom drink, and a family, alarmed by the pattern, that began covertly saving samples of food and vomit for analysis even before Charles's death. The first episode, in Paris in early December, followed the arrival of a cake sent to him from Le Glandier, a gift that struck those around him at the time as an ordinary gesture of domestic affection, sent to a husband traveling on business. He fell severely ill within hours of eating it, recovered enough to travel home, and arrived at Le Glandier, still weakened but improving. It was during his convalescence at home, over the following weeks, that the second and more prolonged phase of his illness developed, a cycle of apparent recovery followed by sudden relapse that several household staff, questioned only after his death, would describe as tracking closely with specific meals. An eggnog prepared and brought to him personally by his wife on more than one occasion, and glasses of sugared water administered during the night, at hours when, according to servant testimony, other members of the household were asked to withdraw. One servant later testified to observing a white, granular substance settled at the bottom of a glass prepared for the patient, a detail that would prove consequential once formal chemical analysis began, though at the time it registered to the servant only as something unusual enough to mention to another member of staff rather than anything requiring immediate alarm. Charles Pouch Lafarge died on the 10th of January, 1840, after a final and severe relapse. The immediate cause recorded by the attending physician was gastric inflammation, consistent with, though not yet proven to be, poisoning. It is worth noting explicitly, in the interest of the same restraint this account has tried to maintain throughout, that gastric inflammation of this kind was not in itself an unusual diagnosis in the period for a variety of naturally occurring illnesses, and that the physician's initial notes reflect genuine uncertainty rather than an immediate accusation. In the final hours, according to depositions taken afterward, Charles was attended almost continuously by his wife, who is recorded as having prepared what would be his last drink herself, sending servants away from the sick room on the grounds that he needed quiet rather than company. No one who was in that room that night ever testified to seeing anything more than a devoted wife. Suspicion of poisoning developed only in the days that followed, as family members compared notes on the pattern of his illness, and as the samples they had already begun preserving were brought to a chemist for analysis. The concealment, such as it was, did not take the form of hiding a body or fabricating an alibi. It took a more mundane and, in some ways, more damning form: the continued administration of substances to a visibly deteriorating man, and, according to testimony, reassurances to family members that his illness was nothing more than a stomach ailment common to the district's water and diet. Samples that family members had begun secretly preserving, grains from suspicious powders, portions of food, and eventually, after death, organ tissue, were handed over to authorities almost immediately, which meant that whatever concealment had been attempted collapsed within days rather than months. The discovery of the case, in the sense of the moment authorities were first alerted, arose not from any brilliant deduction, but from the ordinary suspicion of relatives and household staff who had watched Charles's illness follow an irregular course, and who had, independently, begun keeping their own record of what he ate and when he worsened. It was a family member, alarmed by the coincidence of the recently signed insurance policy and the sudden, relapsing illness, who first raised the possibility of poison aloud and who insisted that samples be tested, a demand made before Charles had even died, a detail that would prove significant, since it meant the earliest physical evidence in the case was collected while the alleged victim was still alive. What that testing would reveal, however, was not going to be simple. It would take two different chemists, two different methods, and one exhumed grave to get there. The investigation that followed moved chronologically through several distinct phases, each adding a layer of scrutiny the previous phase had lacked. First came the local chemist's test on saved samples of food and drink, conducted in the days immediately surrounding Charles's death, which produced a result the chemist himself considered suggestive of arsenic, but not conclusive by the standards then required for a capital case. This first chemist, a pharmacist of local standing rather than a specialist in toxicology, used an older precipitation method that produced a discoloration he associated with the presence of arsenic compounds, a test that had been in use for decades, but that was known, even at the time, to be vulnerable to false positives from other substances present in ordinary food and medicine. Second came the formal post-mortem examination, conducted shortly after death by physicians attached to the local magistrate's office, in which the stomach and other organs were removed and preserved for further analysis. Standard procedure in a suspected poisoning, but complicated in this instance by the local chemist's report being so ambiguous that magistrates felt compelled to seek outside expertise before proceeding further. The organs, along with samples of the suspect food and drink already gathered by the family, were sealed and sent toward Paris for a more authoritative opinion, a step that itself consumed several weeks, and that the defense would later characterize as introducing its own risk of degradation or contamination during transit. Third, and this is the phase for which the case would become historically significant, came the involvement of Mathieu Orfila, the most prominent forensic toxicologist in France at the time, based at the Paris Medical Faculty, who was asked to review the earlier findings and, if necessary, conduct his own tests using a refined version of a chemical procedure for detecting arsenic that had only recently become standard practice in European forensic medicine. Orfila's initial review of the materials sent from Corrèze was, by his own later account, inconclusive on first pass, prompting the request for an exhumation of Charles's remains that would eventually be followed by a second. Marie Lafarge's arrest was not the product of a manhunt in any conventional sense. She made no attempt to flee, and there was no chase. She was already resident in the household under a cloud of suspicion that had been building publicly for days by the time magistrates formally placed her in custody. In the weeks following Charles's death, once the preliminary chemical findings and the pattern of servant testimony had accumulated to a point local authorities considered sufficient for formal charges. She was taken into custody at Le Glandier itself, in the presence of relatives who by this point had largely turned against her, and transported to await trial in circumstances the contemporary press described as subdued rather than dramatic. No struggle, no pursuit, only the quiet execution of a warrant against a woman who had nowhere obvious to run and, by her own account, no plan to try. If there was an element of chance in how the case against her hardened, it lay less in her arrest and more in the earlier decision by relatives to preserve samples of food on their own initiative, an act of amateur suspicion, not professional investigation, that supplied prosecutors with physical evidence they would otherwise have lacked entirely. The medical and forensic testimony that followed became, in the words of legal historians who have studied the case since, one of the first instances in which a French courtroom was asked to evaluate competing chemical analyses as the central evidentiary question in a murder trial. The initial local chemist, using an older and cruder precipitation method, had produced ambiguous results. Traces that might have indicated arsenic, or might have been an artifact of contamination or faulty procedure. The defense seized on this ambiguity, arguing that no reliable proof of poisoning existed at all, which left the case balanced on a single, unresolved question. Could anyone in France actually prove what was in that glass? There was only one man they trusted to answer it. It was this dispute that led magistrates to call in Mathieu Orfila, dean of the Paris Medical Faculty, and, by general professional consensus of the period, the leading authority on poisons in Europe. Orfila applied a more sensitive test than the local chemist had used, a method involving the reduction of a sample to arsenic gas through reaction with zinc and acid, and the subsequent deposit of any arsenic present as a visible metallic mirror on a cold surface placed in the gas stream. The procedure, sensitive enough in principle to register quantities far below what older precipitation methods could reliably detect, had been developed and refined only a few years earlier, and was, at the time of the Lafarge trial, still unfamiliar to much of the French legal and medical establishment. Its introduction into open court, with two opposing teams of chemists disputing each other's technique before a jury of laymen, was itself an unprecedented spectacle. Orfila's initial application of the test to organ samples exhumed from Charles's grave produced results the defense's own experts disputed on procedural grounds, arguing variously that the reagents used might themselves have introduced trace arsenic, that soil at the burial site could have contaminated the remains, or that the equipment employed had not been adequately purged of residue from prior use. Any one of those objections, if it held, would clear her. These were not frivolous objections. Contamination was a genuine and recognized hazard of the test, as practiced in this period, and the defense's chemists included men of serious professional standing. For a moment, the entire prosecution rested on whether a second dig could settle what the first one hadn't. The dispute grew heated and public enough that magistrates ordered a second exhumation, conducted this time under conditions designed explicitly to foreclose the contamination objections raised at the first. Fresh reagents purchased and tested for purity before use, new glassware, and the analysis conducted in view of representatives from both prosecution and defense. Orfila's second determination, delivered directly to the court, held that arsenic was present in the remains in quantities that could not, in his professional judgment, be explained by contamination, embalming materials, or any naturally occurring source, a conclusion he defended under direct and lengthy cross-examination by defense counsel determined to find any procedural flaw that might undermine it. The inquest, conducted in the weeks following Charles's death and preceding the criminal trial proper, gathered together the preliminary chemical findings, the post-mortem report, and the initial statements taken from household staff, and formally recorded a verdict of death by poisoning. This finding cleared the way for a full criminal prosecution. What followed at Toul, the departmental seat, would turn all of this preliminary evidence into a public spectacle. The trial, opening in the late summer of 1840, lasted several weeks and drew press attention from across France and, before long, from London and other European capitals. The prosecution's case rested on three pillars: the financial motive supplied by the ironworks debts and the recently signed insurance policy, the pattern of opportunity established by servant testimony regarding who prepared Charles's food and drink during his final illness, and the forensic evidence, culminating in Orfila's testimony, establishing the presence of arsenic in quantities the prosecution argued could not be explained by any innocent cause. Prosecutors also introduced the separate diamond theft accusation from the Léotaud household, not as a formal charge within this trial, but as character evidence intended to establish a pattern of calculated deception. The defense, led by prominent counsel retained at considerable expense, mounted a two-part strategy. First, they attacked the reliability of the forensic testimony directly, bringing in rival chemists, including, notably, a chemist who would later become one of Orfila's most persistent professional critics, to argue that contamination, faulty procedure, or the natural presence of arsenic in certain soils and embalming materials could account for the results without requiring deliberate poisoning. Second, the defense argued that no witness had directly observed Marie Lafarge administering poison, that the entire prosecution case was circumstantial, and that a conviction on such evidence, however sensational the surrounding publicity, would represent a dangerous precedent for French criminal justice. The proceedings at Toul stretched across multiple weeks and drew a courtroom crowd so large that additional seating had to be arranged, along with a press gallery occupied daily by correspondents from Paris and, before the trial's end, from newspapers as far away as London. Witness testimony proceeded roughly in the order the underlying events had occurred. Household servants first, describing what they had observed of meals, medicines, and the pattern of Charles's illness. Then relatives of both families, describing the courtship, the marriage, and the disputed insurance policy. Then the procession of chemists, prosecution, and defense in turn, whose competing technical testimony occupied a disproportionate share of the trial's later sessions, and which correspondents at the time openly acknowledged struggling to render intelligibly for a general readership. The diamond theft accusation from the Léotaud household was introduced during this same stretch of testimony, not as a charge to be adjudicated in this proceeding, but, as the prosecution framed it, as evidence bearing on the defendant's character and her willingness to deceive those closest to her. By the trial's final week, nobody in that courtroom was arguing about a marriage anymore. They were arguing about whether chemistry itself could be trusted with a woman's life. This scientific dispute, conducted in open court between competing experts before a jury of laymen with no specialized training to evaluate it, was itself a novelty, a preview of the kind of adversarial forensic testimony that would become standard in criminal trials only much later in the 19th century, and one that left contemporary legal commentators visibly uneasy about asking untrained jurors to adjudicate a dispute between chemists. The jury's deliberation itself is recorded, by press accounts present outside the chamber, as unusually lengthy for a provincial assize trial of the period, a length several correspondents attributed directly to the difficulty laymen faced in weighing the competing chemical testimony against each other. Whatever they decided next would either validate Orfila's science in the eyes of all of France, or destroy it. When the jury returned, it delivered a verdict of guilty of murder, but, critically, and this is the detail that alters the remainder of this account from the template most such cases follow, with a finding of extenuating circumstances, a mechanism available under French criminal procedure of the period that allowed a jury to acknowledge guilt on a capital charge while directing the court toward a sentence short of death. Contemporary legal commentary suggests this qualification reflected lingering unease, even among jurors who accepted the forensic evidence, about sending a woman of Marie Lafarge's social standing to the guillotine on the strength of a chemical test few in the courtroom, including some of the jurors themselves, felt equipped to fully evaluate. Sentencing followed the jury's verdict directly. The presiding judge, in remarks recorded by press correspondents present in the courtroom, characterized the case as a grave betrayal of domestic trust, compounded by a calculated use of financial instruments, the insurance policy chief among them, to convert marriage into a transaction with a lethal endpoint. He is recorded as noting, in substance rather than exact quotation, that the extenuating circumstances found by the jury did not diminish the gravity of the offense, but only the severity of the punishment the law would exact for it. The sentence pronounced was forced labor for life, accompanied, under the law then in force, by a period of public exposure in the pillory, a ritual humiliation performed before sentence was carried into effect, in which the condemned was displayed publicly, bearing a placard naming the crime, a practice retained from an earlier era of French penal custom and applied here to a defendant whose case had already made her one of the most recognized faces in the country. There would be no execution. There would be, instead, decades. What followed was not an execution but imprisonment, and the years that followed are documented with a mixture of official record and public fascination that rarely faded. Marie Lafarge served her sentence first at Montpellier, in a facility that housed women convicted under the extenuating circumstances provision, alongside those serving lesser terms. The regime there was strict but not, by the standards of the period, unusually harsh. Supervised labor, communal quarters, correspondence subject to review by prison authorities, and visits from family permitted only rarely and under observation. It was within these conditions, and largely because of them, that her health, always fragile, declined steadily. She is recorded in prison medical reports as having developed tuberculosis within a few years of her incarceration, a disease that moved through crowded 19th century prison populations with grim regularity and that offered, by this period, essentially no effective treatment once established. Prison did what the poison trial could not. It slowly, unglamorously killed her anyway. Public sympathy for her case, driven in part by her own published memoirs written from prison, a document historians treat cautiously, given its obvious interest in shaping her legacy, its selective account of the marriage, and its presentation of herself as a wronged party rather than a convicted poisoner, grew steadily through the 1840s. The memoirs sold widely, were translated into other European languages, and kept her name before a reading public that had never lost interest in the trial's more sensational details. Petitions for clemency circulated among sympathetic members of the public and, eventually, reached figures close to the government. This pressure culminated in a pardon granted on grounds of terminal illness by the government of Napoleon III in 1852, more than a decade after her conviction. She was released that same year and died within months, still in her mid-30s, her case already established as a fixture of both legal and popular memory well before her death closed it. The legacy of the case rests less on Marie Lafarge herself than on the forensic method her trial forced into public and institutional prominence. The courtroom dispute over Orfila's arsenic test and his eventual demonstration of it under adversarial scrutiny is treated by historians of forensic science as a foundational episode in establishing chemical toxicology as an accepted form of courtroom evidence in continental Europe, a case cited, in the decades that followed, in textbooks and legal treatises as the moment expert chemical testimony first bore the full evidentiary weight of a capital prosecution. The controversy the trial exposed, that a criminal verdict could hinge on a chemical test that most jurors and many judges could not independently evaluate, also fed directly into subsequent reforms in how expert witnesses were selected, cross-examined, and instructed to explain their methods to lay courts, reforms that unfolded gradually across French and other European jurisdictions over the following decades. Later commentators have also revisited the case as an early instance of a criminal trial shaped as much by mass circulation press coverage as by the courtroom proceedings themselves, a dynamic that would recur throughout the following century and beyond, in cases far removed from provincial France or the 19th century. Modern toxicologists and legal historians continue to cite the Lafarge proceedings when tracing the institutional lineage of forensic chemistry's admission into criminal law, and the case retains a standing place in histories of forensic science precisely because it marks a hinge point, the moment a courtroom first had to decide, in public and under intense scrutiny, how much weight an invisible chemical trace could be permitted to carry against a defendant's life. The case of Marie Lafarge was the single matter examined in this account. The conviction was entered, with extenuating circumstances attached by the jury's own hand. The sentence was forced labor for life, carried into effect in 1840, ending only with a pardon and her death in 1852. The case became part of the national record. It has not left,